Good evening, everyone. I again welcome each one of you to the social studies class of the angels. We have already started the chapter, the judiciary. We discussed about the Supreme Court, we discussed about the high courts, we discussed about their functions, how the judges are selected, the removal of judges, even we discussed that day. Today we shall be talking about the subordinate courts. See, in a state, the judiciary consists of high court and subordinate courts. In a district, there are two types of courts, the civil court as well as the criminal courts. The highest civil court in a district is the court of the district judge. The court decides civil and criminal cases. When the judge decides civil cases, he or she is called the district judge. And when he deals with the criminal cases, he is called the session judge. District judge is appointed by the governor of in consultation with the chief justice of the high court. See, this basic difference most of us do not understand. The basic difference between a session judge and a district judge. We must all understand that when a judge decides the civil matters, the same judge is called the district judge. And when he hears the criminal cases, he is called the session judge. Basically, the same appointment, but it differs. For criminal cases, he becomes the session. For civil, he becomes the judge. So this is how in general also we call him the district judge. Okay. The session court are the courts of the see the session court in a district is the highest, and below him are the courts of the first class magistrate, and even below there are courts of the second class magistrates and the third class magistrates. Now we shall be talking about the public prosecutors. The prosecutors are agents of the Attorney General of India. They work on behalf of the Attorney General of India, and they represent the interest of the general public in criminal justice system. See, they are there, a public prosecutor is there to protect our valued rights, freedoms, and convict only the guilty. His main duty includes that a person who is not guilty should not be punished, and similarly he makes a balance between our rights, our freedom, and of course he has to also look after the guilt. So that way the prosecutor job is to recognize these different and competing interests and conduct the prosecution business in such a way that it best serves all. See, the public prosecutor, they are the representatives of all. They are not the representative of one special interest group. No. They represent the public. They represent us all. That is why they do not act as lawyers for the victim of the crime. No, we should not understand that um, they are just the lawyers. No, they are different people and they make a balance. The public prosecutors represent the interest of all of us and they ensure that the prosecution is conducted in such a way that it is diligent, competent, and it is conducted in a fair way. See, it is conducted, he has to ensure that it is conducted in such a way that the respect for the rights of the citizens is also looked after and the guilty has to be punished. So that way a public prosecutor's job is really to balance between the rights, the freedom, and of course the guilt. So the relationship between the public prosecutor, the police, and the courts, although they are interconnected, but one is one does not serve under the other. They are interconnected with each other, the police, the courts, and of course the prosecutor. They have their responsibilities in such a way that they depend on each other to fulfill their responsibilities, and each also has a legal duty that separate them from others. So that is a fantastic thing. They are interconnected also and they are independent of each other also. The police, the public prosecutor, and the courts. When we are talking about the prosecutor, he or she does not do direct action, and when the prosecutor appears before a court to present a case, he or she enjoys no greater rights to be heard. He enjoys all the rights equal to what others enjoy. He does not have any special rights to present a case and he is not preferred greatly in comparison to the defendant. That is a fantastic thing. Even the defendant has to be given equal chance. So, such a beautiful is our law. See, when we talk about the public prosecutor, the police, and the courts, so naturally the case has to start with the FIR. The first information first has to be registered at the nearest police station. So it has to start from there. What is this FIR? A first information report, FIR we call it generally, is a written document prepared by police in India. It is a report of information that reaches the police first at the point of time, and that is why it is called the first information report. Generally, a complaint lodged with the police by the victim of a cognizable offense or by anyone, he may be a relative or maybe a person who has seen the offense. A cognizable offense can be reported by anybody. The person needn't be a relative of the victim. Anybody can report. And see, the reporting can be done in a written form or even by telephone, orally, in whatever way. And the police has to register it. After registering the complaint, then starts the investigation. And the FIR is very important document as it acts the process of criminal justice in motion. From there, the motion is set. The case starts from the FIR. This is the reason the most important thing is the FIR in any case. After the FIR is registered, the police station that the police takes up the investigation. We have already talked about it. And anyone who knows about the commission of a cognizable offense can file an FIR. We have already talked about it. Now, see, a police officer who comes to know about a cognizable offense can file an FIR himself without anybody's report. See, there is a crime and nobody has reported it. Even if a police officer comes to know about it, he or she himself or herself can file FIR. So that is the procedure, and from there the report is as described in law. Let's know. First thing, when the information about the commission of a cognizable offense is given orally, the police must write it down. That is number one. Number two, the person giving information or making a complaint has a right to demand that the information recorded by the police be read to him or her. And once the information has been recorded by the police, it must be signed by the person giving the information. So these three things are very important. The first one is that when the information of the commission of a cognizable offense is given orally, the police is bound to write it down, and then the person can ask the police to read out it. They are bound to read it out. They will read it out to you, and then of course they are bound to take your signature, and you can ask one copy of the FIR. So we have talked about how our subordinate courts function, how there is a relationship between the police, the public prosecutor, and the courts. They have got such a beautiful relationship that they work in tandem, but one does not work under the other. They are all three are independent. And then we talked about the FIR. Please keep revising, keep reading the text, read at least twice, watch the video once again, and I'll be sending you exercises to do tomorrow. Thanks for joining.